Good morning and welcome back to another webinar in our series of Pulling Back the Curtain. Today we're going to talk about powers of attorney and why everyone should really have a financial power of attorney in place. There are different kinds: healthcare power of attorney and financial powers of attorney. Today we're going to talk about financial powers of attorney. And what a lot of folks don't realize is if you've got assets in your own name, a checking account, investment account, anything that's not a joint account, if something happens to you and you can't act for yourself, nobody else can get access to those accounts. And if you have a house that's in joint names, even with your spouse, if something happens where you're not able to execute a deed, you don't have capacity for whatever reason, the house can't be sold. So you really need to have a power of attorney. It's probably more important than a will. You need to have one of these in place long before you have the need for it. Get your estate planning documents done, put them in a drawer, and hope that you don't need them. But if you do, you'll be glad that you took the steps to get at least your essential estate planning documents: your will, your living will, your financial power of attorney, your healthcare power of attorney. We'll talk about wills and living wills and healthcare powers of attorney in another webinar, but today we're going to focus on financial powers of attorney. Let me pull up the presentation. And here we go. If you've got any questions, just type them in the chat and I'll try and answer them as we go along. If we don't finish all the questions, we'll answer them at the end. Here's who I am. I've been an attorney for over 30 years. I focus on real estate and estate planning and elder law. I'm a certified financial planner, registered investment advisor. I've actually written a book, and if you'd like, email me and I can send you a PDF copy of it. It's not that long, but it's how to protect your lifelong savings and your children's from the costs for long-term care should you become disabled. That's almost a book in and of itself. But I wanted to make sure people understood that there are strategies that you can engage in so that you don't have to go broke in paying for long-term care. Nursing home costs are $12,000, $13,000, $14,000 a month. And you need to be able to engage in planning. If you can't in advance, even if you're in the nursing home, we can help save you maybe half of your assets, so or more. It depends on what your income is. So if you're thinking about family members that may need long-term care, if you want to talk about long-term care asset protection for yourself, give us a call or send us an email. We'll give you our contact information at the end of this webinar. Who needs power of attorney? Well, everybody talks about having a will. Wills are for what happens after you die. Powers of attorney are for when you're alive. And so what's really more important to you? It's something that's going to affect you while you're alive. You really need, like I said, a power of attorney is more important, in our opinion, than a will. You need both, but you need a power of attorney. What is a power of attorney? People abbreviate it POA. Power of attorney is a legal document where you have a principal and an agent. You would be the principal if it's your power of attorney, and you would appoint another person called the agent to act for you. And again, it can be for financial reasons, for healthcare purposes, if you become incapacitated or otherwise unable to act. Everybody says, well, can my spouse or my husband, my wife, my adult children act for me? No, they can't, unless they can't sign documents for you unless you appoint them by a power of attorney. In fact, you can't even act on behalf of your adult children unless they appoint you. So if they're in a university, the university will let you pay but they won't give you any information. You can't get access to any of their courses, their grades, their health care. So you want to think about, if you've got adult children over 18 years old, you can't get their information unless you have a power of attorney where they appoint you as an agent. Again, what happens if I don't have a power of attorney and you need somebody to take action? Well, you can't buy a house, you can't sell it, you can't mortgage it, you can't lease it. Okay, that's your home. So if you want to engage in strategic planning to protect your home, for example, and you're going into a nursing home and you want to make sure that your spouse is protected, if you don't have one of these in place, it makes that planning almost impossible. You can't make gifts or change beneficiary designations, retitle assets that are all essential parts of asset protection planning. Those are ways to make gifts. You want to change beneficiary designations, for example, so that you're not going to be the beneficiary of any more accounts. That could make them subject to paying for long-term care. People can't pay your bills. They can't sign your checks, not legally. You can't buy or sell a car. Can't sue somebody or defend against lawsuits. You can't enter into contracts. You can't authorize or refuse or many healthcare treatments. Again, you can't take all the steps necessary to protect assets from impoverishment from nursing home costs. Well, people say, why don't we just sign the power of attorney when we need it? Because the ship has sailed. You know, if there's certain things that you can't do, you can't get fire insurance when your house is on fire. You can't get long-term care insurance if you need it. If you don't understand what a power of attorney is, a legal document, you can't sign it. So you have capacity one day, and the next day you don't. Well, you can't execute a power of attorney if you don't have capacity to do that. And then again, there's the old saying, well, I've got a power of attorney. I'm good. Well, 95% of the powers of attorney don't have the right provisions to engage in asset protection planning. The elder law is a specialized area of estate planning, and the powers of attorney we have are probably 14 pages long that have all the powers necessary for your agent, the person you appoint, to help protect your assets. Again, not all powers of attorney are created equal. There's a durable general power of attorney. That's what we use for asset protection planning. And it deals with financial matters and is comprehensive. There are also things called springing powers of attorney that are only effective upon the occurrence of some event. We don't like those. When you need a power of attorney, you typically need it right away. You can't wait for 2 doctors to verify that you don't have capacity and that the power of attorney should be in effect. It's really not something that we would use in asset protection planning. And again, there are different kinds of powers of attorney. You can have special powers of attorney, limited powers of attorney, a bank power of attorney, or so when you go to a bank, you may sign a piece of paper to give somebody authorization to access your account. You know, that's simple, that single account. You may give somebody authorization to represent you at a real estate closing. Those are limited powers of attorney. Powers of attorney that we're talking about for asset protection planning, much more comprehensive. And again, we'll deal with healthcare powers of attorney in another webinar. And it's not the same as a living will. Healthcare power of attorney lets your agent authorize or refuse treatment and access your health records and act for you in making healthcare decisions. Again, that we'll deal with that in another presentation. So for asset protection planning, there's certain things, there's a statute in Pennsylvania that outlines what needs to be in a power of attorney and what powers you specifically have to reference. And there are 8 hot powers of attorney, and we've listed a few of them here. You need to specifically give your agent broad authority of to be able to gift, and you have to specify who can get it, who can receive the gifts, what it is they can receive, when they can receive it, why and how. You know, there are very specific It's very specific language that needs to be contained in order for your agent to engage in the kind of gifting that is necessary to protect your assets. Again, the power of attorney has to give your agent the power to retitle assets and add people to accounts and take people off and create and fund trusts. We use trusts quite often, certain types of grantor trusts and asset protection plan. And again, change beneficiary designations. You want to give your agent the power to change beneficiary designations so that you don't receive more assets that could disqualify you from having the government pay for your nursing home costs. And also, you need to specifically authorize your agent to be able to benefit financially in most cases, right? So there has to be certain language in there for your agent to maybe gift to themselves. So if your power of attorney doesn't have that specific language, they can't engage in the asset protection plan that you're really going to need to get the government to pay for your long-term care. And again, can I just have a power of attorney that says my agent can do everything? Can't do it anymore. The statute says that you need to have certain things in the power of attorney that permit them to do. And as a practical matter, banks and other financial institutions, they're not going to honor a power of attorney that's like that. They want to see more specific detail to know that you are authorized by the principal, by if it's mother, father, sister, brother, that gives you, their agent, the power, that you have the power to act on those accounts. Now, what you got a balance here. You want to give your agent lots of authority, the ability to retain control, to do anything that you could do, but you're giving them a lot of power, and that creates an issue for the opportunity for financial abuse. They could take all of your money. So you have to trust. You have to have a strong degree of trust in your agent. Okay. The good side, the power of attorney allows you to retain control over your affairs if you become incapacitated by giving guidance to a person you designate as your agent who will step in and do what you want to be done. So you have an agent, and you should talk to the person who will be your agent. Make sure they understand what you want to be done, because presumably, if they're acting for you, you don't have the capability of acting for yourself. Now, if you don't have a power of attorney, then you have to go to court, and they'll decide what is best for you, and it may not include asset protection planning. So you really don't want somebody that you've never met to make decisions of what will impact you and your family in a potentially catastrophic way. Again, the bad side of one of these powers of attorney, when you give somebody broad authority, is if your agent's dishonest or incompetent or just doesn't act in a timely manner, you can lose everything. And this happens. So it's elder abuse, financial abuse. It's a big problem. So you have to be very careful. In fact, in the powers of attorney that we draft, it says exactly what's in bold capitalized letters on the screen. The law permits you, if you choose, to grant broad authority to an agent under a power of attorney, including the ability to give away all of your property while you're alive, or to substantially change how your property is distributed at your death. You have a will, and you give one of your children a certain bank account. Well, if your agent changes the beneficiary on that account with the bank, it's not going to pass by your will. It's going to pass by the beneficiary designation. Beneficiary designations can change your whole estate plan, and it's very important to coordinate those. It's not just drafting. I'll draft a will, I'll draft a power of attorney, and then I'm done. You have to coordinate that with your accounts, because accounts with beneficiary designations do not pass according to your will. Pass according to beneficiary designations on your IRA, for example, on your 401k. May have beneficiary designations on life insurance. And you should have beneficiary designations on life insurance. Some attorneys recommend putting restrictions on agents to prevent that kind of financial abuse, but we think it's a better alternative to find the right person and don't tie their hands. And there are ways, if you can't find somebody that you have full confidence in, to give them the authority to act, but the powers of attorney are the preferred choice. What does the agent have to do? The agent has a fiduciary duty that they've got to act in your best interests. They're representing you. It's the same as an executor, a trustee, or a guardian. They're examples of fiduciaries. They're supposed to act in your best interest. Now, you can waive a lot of duties that the agent has, except there are three in the law that you cannot waive. You can't waive the requirement that they act in accordance with your reasonable expectations. People think, well, I've given somebody a power of attorney, so they can go and do whatever they want. No, they can only act if they know that you want to have something done. Even if they disagree, they can't take steps that are contrary to what your expectations are. They have to act in good faith and only within the scope of the authority that you grant them. So if you only grant them the authority to act for you on behalf of some accounts, not other accounts, they can't act on your behalf on the other accounts. Again, we don't, in our documents, we typically don't limit it, but your agent is supposed to step in your shoes and do what you would do if you were capable. So who do I pick and who don't I pick? And just because many people appoint their spouse or their adult children, and that's okay, but you should ask before you start doing that, if do those people have any cognitive impairment, physical incapacity? Are they incompetent, dishonest, spendthrift? Do they gamble? Do they have a drug or alcohol problem? Do they have a spouse? Do your adult children have spouses that kind of run the family? And so if you give the power to your daughter, is your son-in-law really going to be making the decisions? Or if they don't care, if they're indifferent to your wishes and to helping you, those would not be good children to pick to be your agent. And then you can't just assume, if you're going to pick somebody that's a friend to be your agent, you can't just assume that they would be willing to act for you and drop everything that they're doing, because when a power of attorney is needed, typically actions have to be taken right away, and that will disrupt the agent's life. So you want to think about and talk to whoever it is that you're going to appoint to make sure that they're willing to help and make it a priority if they begin to act for you. We don't like joint agents where you have two people that have to agree to act, but we like joint and several, where you make your son and or your daughter your agent, so either one can act, and we have to draft those with specific language so it's very clear that you don't need both. And banks don't like joint agents. It just is problematic in a lot of ways. So you can draft. You can have an agent and then a successor agent, and we do that. We have joint and several, and then we always try and find a successor agent, somebody that will step in case one or both of your agents can't act for you. There's something that happens to them. What can you do besides the power of attorney? Two things. One, a guardianship. We don't like this. I mean, it's very expensive, very slow. The guardian's going to have limited authority. It's expensive, and you have to keep going back to get authorization to act and take certain steps. And the court probably won't. Well, they may, but they might not authorize the type of planning that you need to protect your assets from long-term care. Revocable living trust is not a bad alternative. Still, so you can put your property into a box. That's what a trust is. Think of it as a box, and you can make the rules of who can get in the box and when they can get in it and what they can do with the stuff that's in the box. So and you can be your own trustee. So put everything in the box, and you're the trustee, and you're acting on behalf of yourself. And then if something happens to you, then you have another person who's not an agent, but a successor trustee step in and take control of the stuff in the box. That is, in fact, that's a good alternative if you don't have anybody that you really can trust to act for you as an agent under a power of attorney. So hopefully that gives you some ideas of what powers of attorney can do, and what you need to consider uh, when having one drafted for you. If you have questions, please give me a call on the number that's listed, or email me at the email on the screen, keith@keitheliou.com. Thank you for attending, and we hope to see you at our next in our Pulling Back the Curtain series of webinars.